Welcome, everyone. We are continuing the February 2025 complete course for the UBE, the Uniform Bar Exam. So far, we've done some of the tougher subjects like contracts and torts and real property and con law and evidence and civil procedure, and then business entities and partnerships. So we're cruising along, and we also did a review on the MPT, and these are all really important subjects, but wills and trusts is also very important, and we're excited to have our first guest lecturer. So it's my pleasure to introduce Rebecca, one of our amazing instructors. She practices trust and estate law in New York. She's licensed in Florida too, so she teaches for the Florida bar exam and the UBE. And she's also a triathlon athlete and just overall an incredible instructor. And we're really grateful to have her here today. So without further ado, Rebecca, let's get ready to learn.
Thank you, Andrew. What a great introduction. I think I know some of you, and I'm meeting the other half for the first time today. So yes, I am Rebecca Alessi. I'm an attorney in New York and Florida, and I do trust and estates in the real world. But trust and estates for the bar is not really like the real world, unfortunately. And it's kind of just like every other subject. It's a lot of memorization. But I think a good thing is that it's all essay based on the MEE. So we know once we see essays, we don't really need to know exactly word for word what they want us to say. We can, manipulate things that tell a good story and show our grader that we know what we're talking about. And there, again, is only so much that they can possibly ask, right? If you're going to get a wills essay, you're probably going to get something about the validity of a will. You might get something about, was the will revoked properly? Which will is valid? If it's not valid, what are the intestacy laws? You might get capacity of a testator, things like that. And if you were to get a trust essay, again, duties of trustees, can the trust be terminated either with the court or without the court? What are the elements of a valid trust, the spendthrift provisions that they love talking about, charitable trusts. And again, like that's it. You know what I mean? Like maybe there's a couple like weird ones that we, may pop up. But that's pretty much what your essays are going to look like. So there again is only so much that they can ask, but I think that a lot of the material it's straightforward in a way that if you didn't take wills and trust in law school, I'm not sure if everyone did or didn't. But I think it's like if you learn it for the first time, it kind of makes sense because people know what a will is. So it's not like this crazy concept. But as soon as you start learning like the elements of a valid will and things like that, it does kind of just flow like in our heads. So I don't think it's something that's like super complex, like civil procedure is like brand new statutory language for the first time. But wills and trusts, they do kind of flow. So hopefully with my presentation today, and we can go over an essay. And if you have any questions, then, we can talk about it. And again, I do this in the real world. So if you also want to talk to me like outside of bar prep studies about being an estate attorney when you do pass the bar, I'm happy to. You all have my contact and I can put it in the chat for those who don't. Okay.
Exciting.
So pretty.
Thank
Andrew,
you.
you need to like make yours pretty. I'm just kidding.
I'm actually so happy you said that because I was like,
So
I didn't want it to be too flashy. I want it to be like neutral themed,
That's good.
winter themed.
Going almost to the some Zen experience of the
my only dream is that every presentation by an Ibis Prep instructor for every subject is better than mine so that I get replaced and I just the people want other people than me. That's my dream. So you will not offend me by saying how amazing and beautiful this presentation is. I agree. Beautiful.
Good.
The reason why I don't do wills and trusts because I couldn't do it as beautifully as she does.
Well, let's hope that I live up to that. So, again, highly tested topics are going to be as follows, right? We have will formation, execution, revocation. Also, if anyone has a question, please just unmute yourself and ask, because I'm not really looking at the chat.
If you if you press play from start, I think you could do.
No, you're right. Sorry.
Yeah, beautiful. That's good.
Okay. So we have will formation, execution, revocation, codicils. We can talk about intestacy, will contest, and then all of our trust stuff at the end. So when you are executing a will, you are disposing of probate assets when you pass away. So probate assets are assets that are in your name alone, and they're not jointly owned, and they don't have a beneficiary on them. So if you were to get an essay that says a testator has a bank account with $200,000 in it, that would be a probate asset. If you get a question that says testator has a $2 million life insurance with his wife as the beneficiary, that's not a probate asset. So the will only control the probate assets that the testator has. And a lot of essays will say, you know, the will was duly probated. When they say that, just accept it. You know what I mean? That means that the will is valid, it was probated, and then let's talk about it. I would just keep that in mind for things where the essay is asking you to talk about, you know, after the will is probated, what happens, rather than talking about why it's not valid, right? We don't want to fight the question. If the question says that it was duly probated, just accept that. But there are valid wills that we can probate, and they need elements. And one of them is the testator has to have capacity. And that's pretty simple. They just have to be over 18 and they have to have sound mind. So the sound mind requirement, I've seen in essays where a testator is on his deathbed and he's trying to sign a will. That's okay. Sound mind is a very low standard. You can have Alzheimer's, you can have dementia, and you can have a lucid interval and still have sound mind. So I would be wary about saying that a testator does not have sound mind. If he's super sick or if he's super old, you can still have sound mind. So just, you know, something in our analysis if we see an essay like that. And then some of the formal requirements is that it's signed by the testator. If the testator can't actually sign, like he's too old to sign, he can direct an agent of his to sign or someone to sign at his direction. Also, the signature requirement is super lenient. You can have like a scribble, you can have an X, anything that's intended to be a signature of the testator. Again, these may pop up on essays and we'll know what to write if we see it like that, right? And then the testator needs to sign in the presence of 2 witnesses. The old rule, like the common law rule, is that the witnesses have to be disinterested. So this means if the witness gets anything in the will and they're a witness, that gift to the witness is invalid and it would fall to the residue of the will, and we'll talk about residue. But that was the old rule. So you want to find disinterested witnesses because then your gifts to those people would be deemed invalid. The new modern approach is that you can still have interested witnesses, and it won't, you know, mess up the gift. So just keep that in mind if, you know, you see that on an essay. And then also the essays will tell you, you know, the state A that the will was probated in, you know, follows the modern approach or something like that. Or maybe they'll give you the statute and you just apply the statute. Like I know on my MEE, I actually had the statute given to me on a trust MEE. And I was kind of upset because I wanted to apply the knowledge that I knew, but it kind of just like gave me the answer, which is like good, but also like I just studied so much and I wanted to show them. But don't, you know, shy away from, if they give you a statute with language, there is your statute, you know what I mean? So that would be the signature of 2 witnesses. And then those witnesses must also sign the will, right? So the presence is in the testator is present in front of 2 witnesses when he signs, but the 2 witnesses also have to sign the will, but those 2 witnesses can sign later on, right? So as a testator, I bring my will to 2 people. I say, this is my will and I'm, you know, disposing of my assets upon death. I'm signing it, and you two are my witnesses. And those witnesses are like, okay. And then 2 days later, they sign it, the will, saying, I was there on that day and I saw the testator sign it. That's totally fine. They don't have to sign at the same time, right? So if you see a question that the witnesses 2 days later sign something, you're not going to say it's not invalid, right? So that is those are formal requirements. And a lot of states under the UPC, or states pass their own statutes, they have a self-proving will. A self-proving will has a presumption that it's validly executed, right? So all of these requirements, the signing, 2 witnesses, witnesses sign, this may be objected to, right? So if you offer a will to probate and one family member that doesn't get a lot in the will says, hey, I'm going to object to this. I don't think that the testator had capacity, right? I think he was old. I think he was sick, and I want to object to the will. If you have a self-proving will, which is a attestation clause in the will saying the witnesses see the testator and they are of sound mind and they're over 18, basically just repeating all these requirements in this clause. And then there's an affidavit where the witnesses are signing a separate affidavit saying all of the due execution requirements, right? If you have that, where there's an attestation clause and there's a self-proving affidavit where the witnesses say verbatim, these are what happened, the elements that were met when the will was signed, then it's going to be super hard for someone to object to the will later on, because there's a presumption of due execution. I have a self-proving will. So that presumption is even harder to get around. So again, if we see a will that is a self-proving will on an essay, I'm not going to say that it's going to be able to be objected, right? That's going to be a very, very high standard to prove that it was not validly executed.
Sorry, I just have a question about it.
Yes.
So even in the self-executing will, it still has to go through probation, through the probate in the court, at the court, or it's just like it's valid, so nobody can challenge it.
So all wills have to be probated, every single will. The will doesn't do anything. It's just a piece of paper until you probate it. And when you probate it, you bring it to court and prove that it's valid. That method of bringing it to court and probating it, if it's a self-proving will, it's going to be really hard to object to it. So don't forget, when you are trying to probate a will, by bringing the will to the court and saying, this person just died, here's the will, we're trying to probate it, all of the testator, now the decedent, the person who passed away, all of his family members that may or may not be in the will can object and say, I don't think that's a good will. If they say that's not a good will and they win, then the will is invalid. If they lose, then the will gets probated. So all wills have to be probated to be able to dispose of the assets like the will says. If you have a self-proving affidavit, that's a really hard place to come from to object to it. So all wills have to be probated in order to do what it says, if that makes any sense.
Yeah, thank you so much.
Yep. Also, a side note with probate assets, I said that it has to be in the testator's name alone. So if he had a joint property, right? If you're a joint tenant or you're a tenancy by the entirety with your wife or husband, then that is right of survivorship, right? So when one passes away, the other gets it automatically. You don't have to go through this probate process. You don't have to offer the will to the court and go through that whole thing. They're just the owner as soon as the testator dies. And the same thing with joint bank accounts, right? If you have a bank account with 2 owners on it, as soon as one of them passes away, the other owner is immediately the sole owner. You don't have to probate, right? So probate assets are only in the testator's name alone. Sometimes we may get a question about a holographic will. Again, your essay will say this state follows the laws of holographic wills, right? So typically holographic wills are not really valid in a lot of states, but some states do allow it. And a holographic will is entirely handwritten, right? So it's not typed out, and it's signed by the testator and it's dated, but there's no 2 witnesses, right? So it's just handwritten and there's signing and dating, but there's no 2 witnesses requirement. So if you have a holographic will, typically in common law, it would be okay, like it would be a valid will. But because that's like an old approach, a lot of states are passing laws where they don't agree with this holographic will statute, with this holographic will common law, and they pass these statutes to say, hey, we're not following holographic wills, but we are following like this modern approach where a typed out will, right? A valid typed out will that's signed and dated and has two witnesses. So a will that's ready to go to probate, you can make a change in the margin in handwriting. And then it depends on whether or not that change is then maybe signed next to it. And the statute that they provide you on essay day will show you what's valid and what's not valid in that state. But just to keep in mind that typically holographic wills are only in common law able to be a valid will, which are again, are handwritten, signed and dated, but no two witnesses. And only a couple states in these modern statutes follow holographic wills, right? A lot of states do not accept holographic wills. But if a state did pass something where they are accepting holographic wills, they likely are going to be accepting a small change in the margin of the will in handwriting. So again, if we have an essay that says the testator wrote his will and then signed it on the bottom and then put it in his drawer and there's no two witnesses, then we're going to be talking about holographic wills, right? And then we're going to see if they gave us a statute, and if they didn't, we can say under common law it is valid if it was entirely handwritten and signed and dated, but must conform to the two, but does not have two witnesses requirement. However, if the state passed a statute not allowing it, then it's not valid, right? So just follow the statute that they give you. Oral wills are similarly not really used. That is, again, only a few states, and it's a testator on his deathbed. He can't write a will, so he just expresses his intention to do a will. And either that scenario or there's a soldier on active duty, right? So they're allowed to do an oral will because they're just in combat zone and they can't write out a will. So if a state allows oral wills, where generally they're not, right? Generally, we're not following oral wills. They have to be written. They have to be, you know, on a piece of paper. And if the state does allow an oral will, which only a few states do, it's typically only limited to a certain amount of money, right? So if he has a bank account, $5,000, and he's like, you know, tells this person, I want to do a will where I'm giving this $5,000 to my kid, typically that would be fine if it's only in, you know, a few states that pass that statute. But generally oral wills are no, right? We're not doing that. And so those are wills, right? Those are an instrument that disposes of probate property upon death. A codicil is similarly an instrument that modifies that previously executed will. So it's kind of like an addendum to the will. It's an addition to the will, but it's not a will by itself. It's a codicil. So if I did a will in 2010 and I do a codicil in 2012, and I'm referring to the will that I did in 2010, my codicil is not a standalone will. So if I terminate my codicil, if I rip it up, if I tear it up, my will is still valid, right? Because I didn't tear up my will. But if I have a 2010 will and I invalidate that and I tear it up, then my codicil is also torn up, right? Because that codicil is attached to that 2010 will. And your essay will say that, you know, there was a 2010 will and a codicil that was done in 2012 talking about that 2010 will. And he wants to change, you know, maybe one quick gift in there from what the gift is originally saying in the original will. The thing about a codicil is that it has to be executed in the same formalities, right? In writing, testator signs, it's dated, two witnesses, right? Same as a will. If your codicil doesn't have two witnesses, it's not valid. It needs to have the exact same formalities as a will. There's also a doctrine called republication by codicil. And this means that a will that was done in 2010 is basically treated as being re-executed on the new date of that codicil. So if the will is done in 2010 and the codicil is done in 2012, on 2012, that is where the republication is done. And when we talk about republication, we talk about it in like a string of, you know, he, in between the will and the codicil, he gets another asset. After the codicil, he sells his asset. You know, what does the will refer to? So just on like the time frame of things that the essay talks about, we have to know when the republication date is done. And again, you can have more than one codicil, right? So if we have a 2010 will, a 2012 codicil, and a 2014 codicil, that last codicil that's referring to the original will is the date that that will is being re-executed on. So then we think of that will as now being re-executed in 2014. Any questions about that?
Good question.
Yep.
So far, not so bad. I didn't take it, so it was like this is all fresh for me. But a lot of
Okay.
things, a lot of details are common sense, and we have in real life. So I think it will make sense.
Mhm.
Can you have multiple codicils?
Yes.
And which one prevails? First in, like for like, what is the priority between them?
Totally. That's a great question. So you can have multiple codicils. But again, all of those codicils have to refer to a will. You can't just have codicils and never did a will, right? There has to be an original will, and then all of your codicils throughout the years are all referring to your will. So in your will, you give 10,000 to my daughter and 10,000 to my son. And then 2 years later, you get in a fight with your son and you do a codicil saying, I'm revoking that gift to my son. I only want to give $20,000 to my daughter. And then 2 years later, you do another codicil saying, actually, I made up with them. Now it's back to 10-10. Then that latest codicil that you did prevails. And then, right? So it's the latest one that you possibly could do before you die is the codicil where you have to follow what it says. And then that original will is republished on that latest date.
So that's the republication.
Correct.
And codicil is kind of extension of the original and modification of the original will, right?
Yes.
And it's a separate document, or it can be attached to the original document as an addendum or the paper.
So it's a completely separate document that has to be executed in the same way as a will. So it's kind of like funky to think about because you're like, why don't you just do a new will? And you should. So in my practice in my law firm, we don't do codicils because it gets too confusing. We just do new wills. New
That's
wills,
what
new
I'm about
wills,
to
new wills.
Yes, good.
Yeah, but on test day in bar world, you have codicils, right? So just know that a codicil is basically like you said, an extension of the will, which is on a piece of paper, executed in the same way. But basically the wording of it is just, this is a codicil to the will that I did in 2010, and I am changing a couple of these gifts, and here is the change, and I sign on the bottom, and I have 2 witnesses, right?
Thank you.
Sorry, a question.
Yep.
So a codicil is an option, so you can choose between doing a codicil or making a new will. So you decide which one is better.
Correct. You can do a codicil and change a couple things in the original will that you did, or you can be like, you know what? I just want a completely new will and I'll start from scratch. And you can do that. But like logistically in the real world, a codicil is cheaper because it's going to just be like one little quick document making a quick change. If you do a brand new will, that's like a lengthy document because wills need a bunch of language in them. It's just more expensive. So in real world, people like to do codicils because it's cheaper. But in bar world, your testator on your essay will either do a codicil to that original will, or if they do a will 2010, codicil in 2012 about that 2010 will, and then in 2014, they make a brand new will revoking all prior things that I've ever done, then those codicils and wills from the 2010, 2014 are out of the picture. That new will that I did, you know, later, the latest will prevail. So the latest will or the latest codicil referring to a will prevail. And it might get a little bit complicated on an essay if there's a bunch of dates and there's wills and codicils done. Don't be afraid to just in the margins of the essays, because you get a booklet, with a, pen and paper, you can just quickly say, will was done on this day, codicil to that will was done on this day, but then a brand new will was done. Those are now revoked. And then he did a codicil to his second will, and then he died. So that codicil for the second will that he did is now prevailing, and it's whatever that codicil says, right? Does that make sense? So we're gonna have to write
Right.
out a little bit of like,
Totally, and it has to be probated as
timeframe.
well, right?
Correct. But you're probating the will, right? You're not probating the codicil. Obviously you would have to submit them together, but you need the will to probate. You can't just probate a codicil by itself.
Okay, so you're taking the old will, attaching newly established codicil, and you're kind of reaffirming it. I had real life stories. I was working at JP Morgan, and I had many cases when client died and different family members would bring different documents fighting between each other, and we had to always ask for the court approved and court sealed document. They would bring and fight over with this. There was a lady who would change this every month, literally until she died. That was like a real life story. And like that was the law that it has to be court certified.
Yep. So again, when you offer a will to probate, it may not be probated because someone can object to it and they can win. And then the will is invalid. And then it would go through intestacy, which we'll talk about, right? And intestacy is as if I have no will, right? I never do a will. It follows the law of New York or the law of wherever I am when I die, of my domicile. But again, you can offer a will to probate and it's accepted, and either objection doesn't follow through or nobody objects. And then that will is my probated will by the court, and my executor in my will is appointed. And then that is the document that is court certified, right? So the probate process is just getting the will court certified to then follow what it says, right? I can't follow what the will says unless the court allows me to.
Cool, thanks.
So incorporation by reference. This situation, you will issue spot right away, right? As soon as you see something like this, it's incorporation by reference. And what am I talking about? It's a document that's incorporated into a will. So I have a will and I say I want all personal property to my grandchildren, and I don't specify which grandchildren is getting which personal property. Later on, 2 years later, I'm like, well, actually, sorry, it would be prior to the will's execution. So in 2010, I have a document saying, I'm going to do a will in the future. And when I do that will, I'm going to give this one grandchildren this one grandchildren this. And then when I do my will, it would be incorporated as to the directions that I want. So the necessary elements is that the document that has the detail on it is in existence at the time of the will's execution. And then my will says, I made a document in blah, blah, blah day talking about my personal property, and I'm incorporating it into my will, right? So the document is sufficiently described in the will, and the will manifests the intent to incorporate the document. So your essay will tell you if your will is sufficiently describing a document that was priorly executed, talking about where you want certain things, given to, and then the will manifests intent, where the testator intends that the document done in 2010 is now going to be incorporated into this will, and tell my executor, this is what I want happening to my personal property. On test day, we may get something where we don't have one of the elements. Maybe it says that, the document was made before the will and the document was sufficiently described, and say, hey, there's a document out there floating around in 2010 that I said I wanted to give this to. But did it manifest intent? Did the language in the will manifest the intent to incorporate it? Did the will say, and I intend for it to be incorporated in? Maybe I could argue that it didn't. And then I can make a great analysis and say, by the way, there's 3 elements that are incorporation by reference. I see 2, but I don't see the third. perhaps that this doctrine does not follow through, and then the document is not incorporated, and whatever the will says will prevail, right? Because that document was not validly incorporated, so it's whatever the will says, right? So we're just going to have to memorize these elements. The document was in existence at the time that the will was executed, right? So it was done before. When the will was executed, it was already in existence. And that document that was in existence is sufficiently described in the will, and the will manifests the intent to incorporate it. And that's going to be in your facts. And you're going to have to read and see if you can pick that out. But it's typically something that just puts a little bit more detail into what the will is trying to say, right? If the will is a little bit ambiguous, this document that you quickly said 10,000 to Bobby, 20,000 to Clara, 50,000 to Anna, right? Money or jewelry, clothes, and furniture, whatever it is, and this document that you want specifically provisions in your will to follow, that would be the type of thing, right? So this is, you're just going to have to pick it out of the essay and you'll be able to see it. And I think I've seen this on essays where, again, because it's hard to ask in an essay and make it hard for people, right? Because the test is, they don't want it to be easy. So they're going to pick up this, incorporation by reference, which is pretty straightforward. And they're going to throw a wrench into it and try and get you to get all confused. But instead of getting overwhelmed and saying, well, I think it's incorporation by reference, but maybe the document was done after the execution, right? Perfect. That's okay. I'll still talk about incorporation by reference. I'll still put all the elements down, and then I'll say that one of the elements is not met because of what the facts say in the essay, right? Let's not get ahead of ourselves. If the essay issue spots something, but then we follow through at an incorrect, maybe it doesn't apply, right? And that's okay. If something doesn't apply, at least we have a great analysis as to why it doesn't apply. So when you create a will, you can also revoke it, right? It doesn't have to be the thing that you have when you die if you change your mind. And like we just talked about, later wills, expressly revoking prior wills, will govern, right? So the latest will that says, I expressly revoke all my prior wills, will govern. And in practice at my law firm, every single will says that, because we don't know what these people did before they got to our firm, how many wills they have floating out there. So every single will says, this will expressly revokes all my prior wills. On test day, if we see something where the testator executes a will and it does not expressly revoke, right? They may say that does not expressly revoke all prior wills, then the other will and this new will be read together and as followed as best as possible. And if there are inconsistencies between them, the later will prevail, will control, right? So the latest document that we do will always be the best, but if we do have these inconsistencies, then they will be read together as much as possible. But if there is an inconsistency, it's going to be the later will. So that's how we revoke with a newly written instrument, with a new will. Also, keep in mind that if we do a will and then we do a codicil, and the later codicil is inconsistent with my will, then the codicil will prevail, right? Because the codicil is talking about that will and changing what that will said, right? So just keep in mind that, the general provision is that it's always going to be the later document. Wills and codicils are tied together. So if the codicil changes what the will says, then we have to listen to that codicil. But if we have a will and then another will, we're trying to read them together as best as possible. But if we can't, and there's inconsistencies, it's the later will. Physical act, you would have to see the essay saying testator rips it or throws it in the fire or writes with a Sharpie all over it. If the testator did a, line over one provision, right? And left everything else fine, right? Maybe he got into a fight with his son and the one provision that says I give 10,000 to my son is crossed out. You would have to see if there's a state statute allowing partial revocation, and sometimes they would, and then that revocation from that one bequest, 10,000 to my son, will then fall to the residue. right? And we'll talk about the residue, which is everything else, right? So in my wills, I have specific gifts, I have general gifts, and then I have my residue, which is everything else I didn't talk about. But if I crossed out a part in my will for one person, I would have to see if my jurisdiction allows partial revocation, and then that revocation would go into my residue. But if my jurisdiction does not allow partial revocation, then I can't partially revoke, right? So that cross out is too bad. You're still going to get that 10,000 because I can't partially revoke. But if I fully revoke by tearing everything up and crossing everything out, plus intent, so plus, and obviously intent is just easy to argue, because why would you do that if you didn't intend to destroy it? If you do both of those, then it has been revoked, right? And there is a presumption where if a will is destroyed and it's in the testator's possession prior to death, he revoked it, right? So it's not gonna, there's no argument like, oh, somebody else revoked this without him knowing. If it was in his possession, if it was in his house and it was destroyed when found right before he died, it's presumed that he did that, right? And there's also something with like lost wills, where if you can't find a will and it was in the testator's possession before he died and no one can find it, it's also presumed that it's revoked, it's destroyed, it's gone, right? Because if he wanted it to be found, he would have had it sitting there. But again, if he revoked it or he doesn't want it to be prevailing anymore and it's gone, then the presumption is that it's gone, right? If it was in his possession prior to his death and it's either completely destroyed or it's gone, then it's destroyed and gone, right? Then there's a doctrine called dependent relative revocation. And this, again, you will see on an essay, it will scream at you that this is what they want you to talk about. And dependent relative revocation, DRR, and on essay, I would not type this out, I would say DRR. I would type it out for once and then in parentheses DRR and then talk about DRR the rest of the time. But this is basically where a testator creates a will and then he creates a new will like 2 years later. And maybe that will 2 years later said, I'm expressly revoking all prior wills, right? So that means that his original will is no longer because he did a new will expressly revoking that one. But let's say that will is still in existence. It's still in the attorney's drawer. It's not like he ripped it up. It's still a piece of paper and it's still sitting there. And he did this new will that's also sitting there that's expressly revoking this one. But the testator, I guess, didn't realize that or accidentally forgets or his attorney doesn't tell him. And his new will, he's looking at it and he goes, you know what? I want my old will. I don't like what I said here. I gave my son a lot of money in this one and I didn't give him a lot in this one. And I have a good relationship with him. So I'm going to tear this one up. I'm going to destroy this new one because I think that this old one is going to be valid, but I'm wrong because I expressly revoked my prior will, which means it's gone. And when I revoke this one, I don't have anything, right? Because if I'm expressly revoking it when I create it, it's revoked. So DRR is kind of like a mistaken belief, right? And so I will issue spot this by seeing testator ripped up his will thinking that his old will be able to care for his spouse, and his new will, he doesn't have anything for his spouse. But for this mistaken belief, and this is what you got to be writing on your essay, but for this mistaken belief, testator would not have revoked, right? So if the testator knew that if he revoked this and the old will would not be able to be read and his son would not get anything, right? Perhaps, then I would never have done that, right? So it's a two-pronged thing where he revokes it under a mistaken belief that this will is still going to work. And his mistaken belief is, by the way, you expressly revoked prior wills and this is a prior will that's now revoked. And maybe he didn't understand that, so he's mistaken. And then the second prong is he would not have revoked it if he knew of the mistake, right? And we've seen that in other things in law, right? It's but for this mistake, right? And in actual cause for tort, but for this injury or but for this action, the injury would not occur, right? But for this mistaken belief, testator would not have revoked. So I would definitely memorize that and put that in if I do see something like this where I issue spot on an essay. Anything, questions for this, and I'll keep going.
How many rules, how much memorization do you recommend here?
What do you mean by that? Like how?
Like you have it before that it says memorize this.
Yeah.
Do you have any areas that specifically like we have to memorize, or general concepts, just knowing general concepts and common sense, majority of it will be enough?
Yeah, I think as long as you memorize the names of people, I think that's super important on essay day. So like the person who creates the will is the testator. The person who creates a trust that we'll talk about is the settlor or a grantor, right? The person who gets something in the will is the beneficiary. I think like words for titles of people are super important, but also the doctrines are super important, right? So if I don't remember exactly dependent relative revocation, and maybe I don't remember exactly what my two elements are, at least I know it's dependent relative revocation. I have to know that statutory term because that's what they're looking for on test day. And again, if we do forget, we can explain it to the best of our ability what we mean. But if I remembered the statutory words, then I am in better place than if I didn't, right? And there are, like, I think under the statutory ones, like DRR is a statutory one. We'll look at other statutory ones, but I would definitely focus on the statutory ones rather than like physical act. Burning, canceling, defacing, obliterating, that's kind of like common sense. You know, he destroyed it, right? I don't need to memorize exactly all of those physical acts words, but for DRR, I probably should be focusing on at least doing that a little bit better because it's more of like a concept rather than, you know, physical act is like just whatever the physical act is plus intent to destroy. But again, memorization is like, it's the hardest part because, you know, we study, and then on test day, we're like, oh my God, what the heck did I just look at I looked at my notes 5 seconds ago and now they're not in front of me. And like, it happened to me. And so don't feel like it's the end of the world where you look at your book and you're like, oh my God, 2 hours ago, I was just looking at this. I don't remember what it says. Everyone in that room is going to feel the same way. So as long as you're like, okay, I'm just going to try my hardest to remember, and that is all you can do. If you try your best and you try your hardest, that's, you can't, you know, be too hard on yourself that it's not exactly perfect and word for word because no one's going to write an essay like that. So for specific gifts in our wills, we have specific ones, right? We have a specific bequest, which means my specific piece of property, my ring, I give to beneficiary, right? That's a specific bequest. My house on, you know, Chestnut Road, I give to my daughter. That's a specific bequest. I'm talking about a specific piece of property or a specific piece of tangible property to a person. A general bequest is like money. I give $20,000 to my daughter. Do I care if it's this $20,000 in my bank account or this $20,000 in my bank account? No. If I have $100,000 in my bank account, it's just 20,000 of that 100,000 I give to my daughter. That's a general bequest. You can have a specific bequest with money if it said paid out of specifically this place, right? So I want her to have $20,000 paid specifically out of this bank account that I have in blah, blah, blah bank. That would be a specific bequest if you're being super specific about where that money is coming from. And then like I talked about, the residuary of our wills is everything else I didn't talk about, right? So if I have $1 million in my name and it's in a bunch of stock and a bunch of accounts in a house, and I say I give my house to my daughter and I give $20,000 to my daughter, and then I just say residue to my son, then everything else that I didn't just give away is in my residue to my son. And he probably got a lot more, but the residue can be split by 2 different people, right? 20% to this person, 20% to this person, but the residue just means everything else. And residue comes into importance when one of a specific or general gift fails, right? We'll talk about one of them failing maybe, or something goes wrong with those specific gifts. The residue is then important because if that gift fails, it goes into my residue. So on essay, if I'm trying to write an essay about why a gift is failing, my conclusion would be if it does fail, it would go into the residue of the estate, and whoever the beneficiary of the residue is would get it. And then the residuary also comes into importance where sometimes there will be something called abatement, and I don't have it written here, but I can send something later if you need something on abatement. But abatement pretty much means that there's not enough money in the estate to satisfy the gifts. So if I have $100,000 in my name and I say I give $500,000 to my daughter and I don't have $500,000, then my entire estate will abate prorated, and it will start at my residue where people in my residue will get less, and then it will go general, would get a little bit more less, and then specific would be the ones that are protected the most, right? So if I have a specific bequest where I give my ring to my daughter, and then at the end of the day, I have nothing, right? So then maybe the gift would fail. But technically when you're abating and you just don't have enough in your state to satisfy your gifts, it would start at the residue being, you know, the people are getting less, maybe they're getting prorated, depending on what your statute says. And then you would go, all right, so we just took care of our residue. We'll go to the general bequest. Can anyone in general still get anything? If not, then too bad, right? The stops at the residue. So just think of that in the abatement situation where you'll see on essay day what abatement is, because it'll say testator has not enough money to satisfy the gifts, right? And then we'll talk about all of our abatement elements. But again, like half of it is issue spotting, right? Because we know it, we can read it a billion times and it makes sense to us. And then on essay day, you know, we're reading something and we're like, what is happening? It has to be like an issue spot. You know, that's how we, you know, figure it out about studying to test day and like build that bond. Something that they love to talk about is anti-lapse statute. Anti-lapse is a statutory statute that states have passed to get rid of this lapse statute issue. So basically the old rule, right, the common law rule is I'm giving a gift in my will where I'm saying I give $10,000 to my daughter, but my daughter dies before me. So when I die and my will is ready to be probated, my daughter is not alive to get her gift. The old rule is that it would fail and it would pass to my residuary, right? So that's why the residue comes in place. The gift fails and it passes to my residuary. That was the old rule, but now the new modern rule is that states are now passing anti-lapse statutes where if I in my will say I give $10,000 to my daughter and then my daughter predeceases me, when I pass away, my daughter's already dead, then that gift, it will be saved for her heirs. So that $10,000 for my daughter is not going to go in my residue. It's going to go to her estate. So if she has a daughter of her own, right? My granddaughter, the granddaughter will get the money because of this anti-lapse statute. So basically anti-lapse is saving the gift for the heirs of that beneficiary if that beneficiary is also related to me by a common ancestor. And we are, because she's my daughter, right? I'm related to my daughter by a common ancestor, which is my mother or father, right? So it's always like one up. But it will not be saved if it's for a friend, right? I'm not related by a common ancestor to my friend. So if I give $10,000 to my friend and then he predeceases me and then I die, that's going to go to my residue, right? The anti-lapse does not save the gifts for the beneficiary if the beneficiary is not related to the testator. So just keep those two things separate in our heads, where if I'm related to my beneficiary and they predeceased me, anti-lapse will save it for that beneficiary's heirs. But anti-lapse will not save for a friend, right? If a friend dies before me, that's going into my residue in my own will, not his.
At what point does the close relationship end? Like, do uncles, cousins, do
Yeah,
those count?
yep. So on test day, we would have to say, if we got an anti-lapse thing, we would have to say that the testator is related to the beneficiary by a common ancestor. And
Okay.
then your brother is a common ancestor, right? Because we both have the same grandmother, grandfather, grandparent, right? So the common ancestor is the person before us. So you have a common ancestor with your cousin, right? We both have the same grandparent. But again, if it was like a brother-in-law, you don't have a common ancestor with your brother-in-law. You're only related to them through marriage. So that might be a trick where, yeah, that's my family member, it's my brother-in-law, but we're not related by the same common ancestor. So anti-lapse will not save the gift for that person's heirs, right? So
And if anti-lapse comes up on an essay, they would have to give us the statute, right? Like they would have to tell us in a statute, or should we just assume that if we issue spot like, oh, this might be an lapse, should we just assume that whatever state has
they
adopted it?
they will say that state A has an anti-lapse statute. They
Okay,
will. And they may say that the state follows common law rules of anti-lapse of
Okay.
lapse, right? And then we're like, oh, I'm in my modern rule where it still goes to that friend's state, right? So it's going to be saved for both of them, right? So anti-lapse only saves it for my common ancestors, not for my.
so if we went off the example of you gave to your daughter 20 grand, whatever it was, and then your daughter dies, your daughter has 2 kids, is it just equal, or is it just distributed equally amongst the heirs?
Yeah, so if she only has 2 children, then yes, it would go equally to her 2 children.
Okay,
And when we talk about like intestacy with like per capita and per stirpes, then I don't think they're ever going to give you an anti-lapse and a per capita versus per stirpes because that's too much. But just know that if she only had 2 kids of her own, that's easy. But
Yeah.
if she had 3 kids and one of them passed away with kids of their own, then all right, maybe I'm in like an intestacy type of thing. But typically, if you only have 2 kids and you pass away, they're getting everything equally if you don't have a spouse.
Got it. The spouse wouldn't take an anti-lapse statute, right? Because they're not related.
The relation is to the testator. So if the spouse is related to the testator by some common ancestor for some reason, then yes, it's saved. But it's not because if I'm the testator and I say my spouse, I'm not related to my spouse by a common
Right.
ancestor. There's someone that I met at the bar. You know what I mean?
Right.
So that wouldn't be saved because they're not a common ancestor. So it's only
Yep.
family members with a related common ancestor.
Okay.
Right. So that's anti-lapse. Advancement and ademption are like 2 common doctrines. One of them is with intestacy and one of them is with the will, right? So a will we do to change our intestate laws. And if we never do a will, we have intestacy, and that's just the domiciled laws that we follow. So again, on essay day, it's going to have information on there that's going to tell us what's going on, right? We're not going to really have to guess a lot. But on advancement for intestacy, it's a gift made to intestate distributees, right? So if you're my distributees, you're my next of kin through intestacy. So if I pass away right now and I don't have any kids, it would be, and I don't have a spouse, it would be my parents, right? So they are my next of kin through intestacy. And so my intestate distributees would be my parents at this point. So if I made a gift to them during my life, right? A gift is made inter vivos during life, and I gave them $10,000. And I intended when I gave them that $10,000 for that $10,000 to be applied against the share that they get anyway if I pass away, then that's an advancement. So at common law, that lifetime gift that I gave them is presumed to be an advancement. The UPC reverses it and says that that gift is not an advancement unless I intend and declare in a contemporaneous or written agreement or acknowledge by writing by my parents, right? So either I, as the gifter or decedent, intend in a contemporaneous writing that this 10,000 is an advancement to my parents, or my parents acknowledge that this $10,000 is an advancement by me. Then it would be a true advancement, right? So that's the UPC rule, that no gift is an advancement unless I have this either written contemporaneous or acknowledgement by the parents, the distributees. But at common law, all lifetime gifts given to people are presumed to be advancements. And so what does that mean? If I pass away and I have $100,000 in my estate and I gave $50,000 to my mom 2 months before I died, generally, because I have parents, only 2 parents, and I don't have a spouse or kids, it would be split because my parents would inherit equally. And ideally, my parents would have 50,000 and 50,000, but I gave my mom 50,000 already 2 months ago. So that means that that is contributed against her share. And she's not getting that $50,000. My dad's getting the full 100 because I already gave her 50,000 2 months ago. So that's advancement. Does that make sense? So with ademption, that's when a will is involved. It's similar because we have these, elements that kind of sound like advancement, but ademption is with a will. And so a gift can be deemed. And that's a gift that fails because I already gave it away, right? So I give my brand new Chevy Corvette to my daughter, and I do that 2 months before I die. And then in my will, I say I give my Chevy Corvette to my daughter. Obviously, the gift fails because I just gave it to her two months ago. But this kind of comes more into play when like money is involved, right? If I gave my daughter $10,000 2 months ago, and then I do a will saying I give my daughter $10,000, that gift may be already satisfied if these elements are here, where the will says so, where I'm giving $10,000 to my daughter, but the $10,000 that I gave her 2 months ago, or actually to make it simpler, I give $10,000 in my will to my daughter, but the $5,000 that I gave to her 2 months ago is a satisfaction of this gift, right? So the will says that the testator declares in a contemporaneous writing that the gift is deducted from the will. So I have this is an or, right? So either the will says it in a contemporaneous writing at the same time that I do my will, right? Contemporaneous, I say, by the way, the gift that I gave my daughter is deducted because I gave her something 2 months ago. Or my daughter acknowledges that the lifetime gift is in satisfaction of that bequest, right? So this would come up where I pass away and I leave everything to my parents, right? And I give my mom $10,000 2 months before I die. And in my will, I either say that it's a satisfaction of to my mom of what I gave her, or I do a contemporaneous writing with my will saying that the gift was deducted from the will that I gave her 2 months ago. Or my mom, the beneficiary, acknowledges in a writing saying the gift that she gave me 2 months ago, that's a satisfaction of, what I'm getting in the will. If that are present here, like or, right? It's either 1, 2, or 3. It's not all 3. Then that gift is satisfied, right? And she doesn't get that under the will because I already gave it to her. And that gift to her, that she already got 2 months ago will not be again given to her in my will, and my dad would get more. Right. So it's just they're just called 2 different things if it's advancement through intestacy or redemption through a will, but it's kind of the same concept. And then we also have this idea of extinction where I no longer own that asset upon my death. Like if I have a valuable coin collection and that's a specific gift, right? I give my valuable coin collection to my daughter. And then I don't own that coin collection when I die, then it's an extinction, right? So I don't even have it to give. But if there's something called where the value of that could be treated as supposed to be given to the daughter, but if that's the case, it would fall into the residue, right? So it's almost like I never gave her anything because I don't own it when I die, and you can only get rid of things through your will if you own them at the time of your death. Right. So if I gave it to my son 2 months ago, and then in my will, I say I give it to my daughter, too bad. I didn't own it when I gave it away 2 months ago, right? And we know what gifting is. We gift away with intent to give, and then we give full control over to the beneficiary during life, right? And gifting kind of comes up in real property too. But if I gave that gift away, I don't have that in my estate when I pass away. So I can't, it's an extinction of a gift when my will is probated. So I think everyone kind of knows rights of surviving spouse. Basically, the surviving spouse cannot be disinherited. You cannot disinherit your spouse completely. You have to at least give them what their elective share is. And it's different every state, but typically it's a third of the net estate, and that's beyond probate. So again, probate assets are things that are in your name alone, like a bank account, like a stock, like a car, right? That's all probate. That's in my name alone. But if I have a life insurance with a beneficiary on it, if I made a revocable trust, with revocable trusts are not probate assets, or if I transferred something away 1 year before I died, that's part of my net estate. That's calculated in my entire net estate. And if I did not give my spouse anything, then my spouse can take an elective share of a third of that entire net estate, not just what my will says for my probate assets, everything. And then there's, you know, a time frame of when you have to make an election to take your elective share. But it's basically like to protect the surviving spouse, right? So you cannot disinherit your spouse. So if you see an essay where spouse is getting nothing, or spouse is getting less than the third of the net estate, less than their elective share, and always check if the essay gives you a statute on what the elective share is in that jurisdiction. But if they're getting either nothing or less than the elective share, then they have elective share rights. And I'm going to talk about what an elective share is. I'm going to talk about the way that they can get their elective share, what the net estate consists of. And then I'll be pretty confident in that essay. But you can disinherit your children. So if I disinherit my children and I leave everything to my spouse in my will, totally fine. I can do that, and you cannot object to it because obviously if there's other reasons to object, you can, but there's no statutory protection for children like there is their surviving spouse. You can totally disinherit them. But something that does come up is called a pretermitted child, where I give my children $10,000 in my will, and then I do my will in 2010, and then I have a baby in 2012. That 2012 baby is a pretermitted child because I did a will and then I had a baby after my will was executed. And I meant to say like all my children, right? But I had a baby later. So that baby still takes, right? They still get a cut of that $10,000 split amongst my children because they're pretermitted. I didn't really realize that I was going to have a baby in the future, but I said all my children are going to get $10,000. Compare that with my child Anne gets 5,000 and my child Bob gets 5,000. If I have child C, child Corey, 2 years later, Corey's not in a good position because I specifically named my children in my will, right? So maybe they're not a pretermitted child because I specifically referred to them by name in my will. I didn't just say children. And so that would come into play where maybe they're not a pretermitted child because the other children were specifically talked about and he was not. And also it would not apply if in my will I say, I am intentionally disinheriting every child. I'm giving everything to my spouse, and I'm intentionally disinheriting every child I ever will have in the future. If I saw something like that on essay day, I'm like, all right, there is this pretermitted child right where pretermitted child that are mistakenly omitted from the will can still inherit if they were born after the will was executed. However, this will expressly omits children in the future. Whether or not he has any children, he's still going to give it to the spouse. Therefore, unfortunately, the child is not a pretermitted child and will not take under the will. Right? If I saw something like that, that's
Sounds a little
exactly
bit
what I would
like
write.
wrap structure under the real property.
Wrap.
Yes.
We're gonna, yeah.
It's kind of the future interest is vested in all the inherited or the future heirs of the person. Like it's a
Right.
concept is similar, of course, it's different, but
right, if the will allows it, right, if they just generally say children, then that beneficiary in the future, the child that's born later, has a vested right once they're born in that will. Don't forget, you can always change your will, right? Like your rights don't really vest until they're probated. And this is kind of like outside the topic of the bar exam, but the wills can always be changed, right? It's not like you have one shot at a will and then you can never change it. You can change your mind every single day for the rest of your life and have a billion wills. And until you die and the will is probated, then the rights vest once that whole process happens, right? So just keep in mind, like, there's no right to get anything from someone's estate unless you're a surviving spouse and you have this statute protecting you. But there's no right as a beneficiary in a will that you're like waiting on this person to die and then get your money because you're a beneficiary in the will, because they can always change it, right? So your rights don't vest until it's probated, until it's duly probated in a court of law. Intestacy, this is like, if you're a visual learner, I put these here because these actually help me like put this in my mind. But on test day, if they ask you to talk about intestacy, and when are they going to ask you to talk about intestacy? If a will is revoked, if a will is invalid, if something happens where, you know, they just say like, talk about intestacy, right? But, you know, typically it's like they do a will, the will is invalid for some reason, and then it falls through intestacy. And then we have to talk about, okay, what are the intestacy rules here? And then maybe they say your jurisdiction follows per capita, or your jurisdiction follows per stirpes. Then I would be like, great, I only have to talk about one. But they may say, you know, it falls through intestacy. And then you would be like, okay, so intestacy is as if they never executed a will. Property would pass by the laws of the domiciled state in which the decedent passed away. There are two types of intestacy statutes generally, per stirpes and per capita. In per stirpes, it would go like this. And then per capita, it would go like this. Like that would be my essay if they didn't say which one to talk about. But typically what I like to think about for per stirpes and per capita is per stirpes is like the fair way, and per capita is like, why are we doing it like that? That's how I feel like it goes in my head. But like, if you can see this diagram that I put there, sometimes you get the same result, right? So in per stirpes and per capita, if I have 3 children, and one of them passes away, leaving 2 of their own, but my other 2 alive children don't have any kids, then my 2 alive children get a third each, right? So that's equal. And then the child who passed away, so my grandchildren are going to split theirs, split the child that passed away, right? So let's say C2 is G1 and G2's mom. They're going to split mom's share of a third, a sixth, and a sixth. And that's pretty fair, right? But what we get different results is at the second generation, right? So the first generation is my child, my C's. So I have 3 children, 2 of them pass away, and the child still gets a third. That's the same, right? But then I look at my grandchildren. Then I look at my second generational here. Then once I see that the people are dead, C2 and C3, then at my second generation for per capita, they're going to split it equally. Everyone, whoever's left is going to split it, no matter if it's C2 or C3's kids, it's all split equally. And that's kind of not fair, right? Because G1 gets the same as G2 and G3, but G2 and G3 are children of C3 that should be splitting that C3 share, right? And that's what happens in per stirpes, is that the G2 and G3 split the C3's 1/3 share that would drop down, and then G1 just takes that full 1/3 from his mom, from his C2. And it makes sense because the more children you have, people think like, oh, they'll just keep splitting and splitting. And that's in like a per stirpe situation. But in per capita, as soon as those 2 people from the first generation are dead, as soon as people from when there's a first living taker, which is C1, and then everyone else is dead, whoever those people may be, then I go to the second generation and I split it equally. And that's what I do for per capita. And that's like how I put it in my head. But again, on test day, you're going to do the diagrams. You're going to write it out because yes, you'll speak it through the essay, and you would say a third on the essay goes to blah, 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 and a sixth go to blah, blah, blah. And if you really want to, you can do the math. And if they give you like an equal round number of $100,000, and then they give you a third, I would say like 33,000 or whatever. But you don't really have, I don't think it's like necessary to put the actual amounts in there and they start doing math on test day. Like we're lawyers, not mathematicians. But if you do a third and a sixth and do like the correct fractional share, I think that should be sufficient. But nevertheless, if you get an intestacy thing and they talk about this, it's probably not going to be any more complicated than this diagram. They're not going to do like 1 billion kids and then all those kids have like 1 billion grandchildren and like what the heck. This is the maximum of difficulty I'm sure that they will ask if you get a intestacy statute. But if I see intestacy and I'm like, oh my God, I'm gonna have to do all those diagrams, start talking about what intestacy is. Like just stop freaking yourself out and do your black letter law. What is intestacy? Intestacy is if you never executed a will or you did and it's deemed invalid, your assets will be passed by intestate laws of the state that you died in, that you're domiciled in. And if you have personal property in that state, the intestacy laws of that state will control. And if you have a house in a state that is not where you are domiciled, that state's laws will control, right? So real property always follows the situs. And we know that in like, sometimes in civil procedure, we have that of like, where the injury occurs. But real property always controls where the situs is. So at the state that that real property lies in upon death, that's where the intestacy statutes of that state that the real property sits will control, right? So just split them between personal property and real property. And on test day, they'll say he had a house in state A and he had $10,000 in state B in a bank account in which he died. And then you would apply. But again, I don't think it's going to get any more complicated than this.
I have a question.
Yes.
So when the question is silent about which should apply, so which one should follow, like the per capita or the other one?
Per stirpes?
Yeah, per stirpes. And also also in the Barbary lectures, I think, or JD advising, they give us like 3 different ones, like per stirpes, a different type of it. Is that important? Or should I
per
just focus on?
they probably give you per capita by representation. But it's not going to be different than this diagram, right? The per capita by representation is, it's going to be too confusing to start doing all.
Yeah. So I just focus on this.
Yes, I would just focus on this. And if they don't say what to do, I would apply both to be safe. But odds are they'll say that it follows per stirpes, right? Or this jurisdiction follows per capita, they'll tell you. But for some reason they don't. I'm doing diagrams, right? I'm doing them for both. And I don't think it's going to be that complex because once you see the diagrams, like if let's say I did this on test day and I wrote out these diagrams of who died and then I do all the fractions, I'm basically just typing my essay explaining what this diagram is saying, right? And that's all your test grader needs to know is they're not going to see this diagram, right? That's in your book. So on the computer of which we're typing in the description of this diagram, we'll just say, child 1, if they have a name, Charlie gets a third, and C2, Clara predeceased, so her 2 children will split 1/6 each, right? I'm just typing it in, right? So I don't need to make sure that I'm doing math right and doing fractions right because I did, all of that already. And then I'm just explaining in my essay what I did, right? I don't think if we overcomplicate it, then it's just not. I think the less explanation, the better, because then it's just straight to the point, especially in intestacy. We kind of talked about this where you can contest a will and challenge its validity. Basically, it's if it's not duly executed, right? There was one witness or the testator was not in presence of the other witness, right? He was down the street and called him on the phone, right? You're not in presence. That would be a due execution contest. And then undue influence would be where a person is influencing the testator, right? You should dispose in your property in this different way, right? So there's a couple elements that, you can read for what undue influence is. But typically on test day, if I see that a testator did a will and he left everything to one daughter, and the other daughter is contesting it, saying, hey, that my sister unduly influenced my father, the testator, and these are all the elements about undue influence, and were they met or were they not met? And then if they were met and he was unduly influenced, the will is no longer valid, and it goes through intestacy, and both the kids split everything equally, right? If you didn't have a spouse. So that would kind of be like what the essay would look like. And then for capacity, this would be, I probably wouldn't go into a huge capacity thing unless the essay prompts me to, right? So if I'm just talking about will formalities, all I'm going to say is the testator had capacity, right? But if I see that the essay is talking about the testator, super old and super sick and not understanding what he's doing, then I'm going to start talking about all my elements about capacity, right? The testator has to know what property he has. I have a house. I have a bank account. He recognizes his beneficiaries. I have a son. I have a daughter. He recognizes the testamentary instrument that he's signing. This is a will. And he recognizes that the will disposes of that house, right? This will would give my house to my daughter, right? So it's just 4 things that we have to talk about with capacity. And again, I would be prompted to write out all my capacity things if my essay talks about something going wrong in his head, or he's super sick, he's on medication, he's confused, he's drunk, I don't know, anything about capacity issues, about being in the right mind. And again, if the contest is successful, if the will is deemed invalid, I'm going to intestacy. Intestacy is the laws of which the testator passed away and which he is domiciled. If it's real property, it's the situs of that state. If it's personal property, it's where the testator dies, right? And we're going to have to know that to a T, so that on test day, I'm not really like, oh my God, what's the intestacy black letter law? I did it a billion times and I typed it out a billion times, so I can just spit it out on test day and I saved myself a couple seconds, right? I'm going to go through trusts now. We can take a 5-minute break. It's up to you guys. And we can come back at 5:40 and then we can go through trusts and then maybe do a essay. Does that sound